like to hear from all of you by the end of February. We're already in the middle of February. Uh, and I would like everyone to send me a couple of pages, a provisional outline of a possible project, so we can discuss it immediately afterwards. My intention is that after the spring recess, our classes will be basically discussions of your projects. But for that to be possible, of course, we need to have the projects underway. So please do send them to me. Do give me even your preliminary thoughts. Now, in today's class, I want to begin by returning to the first theme of the seminar of the now dominant style of legal analysis, its diffusion in the world, its dangers, and the possible alternatives to it. And then, having that in mind, then the second theme of the seminar, which is the idea of structure, the basic institutional arrangements and ideological assumptions of a society, and the role that a reoriented practice of legal analysis can play in the reconstruction of the structure. So let me start by returning to the five-step argument, the argument that tried to explain what is controversial or problematic about the purposive, principle-based, policy-oriented practice of legal analysis on its own terms, looking at it, as it were, from within. And you may remember that the crucial parts of that argument lie in the third and the fifth of the five steps. So the first step is the legal analyst should broadly converge over time. They should neither diverge too much from one another, nor individually make transformative jumps in their interpretation of the extant law that are too radical. If any of those anomalies takes place, then there is trouble. The second step of the argument is to say that nevertheless, for the practice of legal analysis to perform its mission, the legal analyst must be able from time to time to reject some of the received understandings of the established law as mistaken. And that's the power that I call the revisionary power, or the power of revision. The power of revision is necessary to the standard practice of legal analysis to distinguish it adequately from an elastic rhetorical medium that can retrospectively explain or justify any set of legal understandings, and therefore comes under a cloud of suspicion as not justifying any of them. If after the fact we can jiggle with it, we can stretch it, we can distort it, to get from it the answer that we want, then we begin to suspect that it has no inherent structure, no ability actually to shape the material and to justify our decisions. So there's a tension between these two necessary attributes of the practice of legal analysis. The attribute of overall convergence and the attribute of allowing and including a power of revision or correction. And this tension is then addressed in the third step of the five-step argument, which says that for the purposive, principle-based, and policy-oriented style of legal analysis to work, at any given time, only a modest amount of the received legal understandings should be rejected. The revisionary power, the exercise of the revisionary power should be moderate. If the exercise of the revisionary power goes too far, then the distinction between making law and interpreting it begins to be undermined. And thus the distinction more broadly between politics and law. If, on the other hand, the exercise of the revisionary power is too rare, too uncommon, too difficult, then we begin to suspect that it is just an elastic rhetorical medium from which we can get any answer that we want. So I pointed out then that there's no easy resolution of this tension, and that none of the candidates for a response seem convincing. Candidates for supplying a criterion by which to determine the appropriate level of revisionary power. One would be just the consensus of the tradition of the community of professional legal experts. It's their consensus that revisionary power should be of such and such a level. And I said the objection to that is that the fixing of the appropriate level of revisionary power in every legal tradition in the world is among the most conflictual issues. So there's no basis to presuppose a consensus about it. A second view would be to say there's a theory, there's a doctrine of the proper roles and responsibilities of each agent in the legal process, the judge, the administrative agency, the private order, and so forth. And the level of revisionary power is determined by that theory. But then the objection is, how can it be that a historical set of arrangements, such as the real legal system is, comes to coincide, to converge with someone's theory? Because after all, the theory is never a collective thing. The theory, unlike the living law of the doctrine, is the product of a single mind, or at least of a few minds. And then in despair, we can turn to a third candidate for the response, which is to say, let's just keep our fingers crossed and hope that if we implement this method of attributing purpose and describing purpose in the language of impersonal policy and principle, we won't be required to revise either too much or too little. It'll turn out all right. So that's the unsatisfactory situation in which we leave the problem of the revisionary power. Then we come to the fourth step in the fifth step argument, which is, what is the basis, the intellectual basis, the conceptual basis, the doctrinal basis on which we reject some of the received legal understandings as mistaken? And the idea is that it has to be a coherent picture. It can't just be a set of analogical arguments. The analogical arguments are always, as it were, the grassroots of legal reasoning. But the analogical arguments don't cohere in a system, in a pyramid of propositions that are ever more general and abstract, and they would not seem to provide an adequate basis. So one way of understanding what the basis is, aside from saying it's the narrative of policy and principle, is to say that this narrative, repeatedly practiced in the law, results in normative pictures of what the relations among people in a particular part of social life and in the law that governs it can and should look like. The relations in the family between the parents and the children, the relations between the worker and the firm, the relations between the government and its citizens, and so on. And those normative, prescriptive models of social life, those prescriptive images of human association, are then one way of understanding how these ideas of policy and principle coalesce into something coherent that can be distinguished from mere analogical reasoning. And we would say that, well, that's the basis. That's what the law evolves toward on this picture, on the self-understanding of the purposive, principle-based or policy-oriented style of legal analysis. Their self-understanding by its own practitioners. Now then we come to the fifth step of the five-step argument, where the trouble becomes explicit. The fifth step of the five-step argument says, there's no good reason to expect that the majority of understandings of the law in any detailed and extended field of law should coincide with a theory-like conception, like these narratives of policy and principle that I just described as prescriptive pictures of a certain part of social life. On what assumptions would such an expectation be justified? So you could say, in social theory, in the theory of history, the assumptions would be the assumptions of what in the history of philosophy is described as right-wing Hegelianism. The real is rational. History is a field of conflict, of struggle, of fighting, practical fighting and visionary fighting. The agents in the fight, in the struggles of history, believe that they are radically distinct from one another. They don't think of themselves as soldiers of a unified army who unwittingly and involuntarily are constructing the same rational edifice. That's not how they view themselves. And everything in the evolution of social thought over the last several generations has converged to discredit and undermine these narratives of 19th century legal thought, like Marxism, that there's a plot. History has a plot. Its plot is there are these indivisible regimes, the modes of production that Marx describes, slave society, feudalism, capitalism, socialism. Each of them is an indivisible system, which, if it is to change, must change all of a piece. That's the binary idea of politics, that politics is either the reformist management of a regime or the revolutionary substitution of one regime by another. So all of that is what has become literally unbelievable, even by its own adepts, that there is a short list of regimes, that each of these regimes is an indivisible system, and that the foreordained succession of the regimes in history, in historical time, is driven forward by laws of transformation. And the result then, the result of the second illusion of false necessity, the illusion of indivisibility, is the binary idea of politics. Politics is either revolutionary or reformist, as opposed to the sense that structural change is always fragmentary. And thus, real change of structure doesn't take this form of the replacement of one indivisible system by another. And the result of the combination of the first illusion of false necessity, that there's this closed set or menu of regimes, and the third illusion, which is that there are these laws governing each of them and governing their succession, is that history has a project for us. So we don't need to have a project because history has a project. But it seems that history doesn't have a project for us. Insofar as there is a project, it's the project that arises deliberately or accidentally from our struggles with one another. So how is it, this is then the substance of the problem in the fifth step of the five-step argument, how is it that viewed after the fact, retrospectively, when it comes into the hands of the professional interpreters of law, the law looks as if it were evolving towards a system. But prospectively, when it was in the hands of the agents fighting about its content, it didn't look that way. The agents thought that they were really deeply divided from one another. And then the judge or the jurist comes after the fact and says, no, you're mistaken. You weren't so divided from one another as you thought. And in fact, you were all acting unwittingly as the agents of the development of a historical plot, which I'm going to describe to you in a vocabulary which you might regard as astonishing, which is the vocabulary of policy and principle, and which shows that it all fits together. So, how can we believe that? Now, and if we did believe that, our idea of popular self-government, of democracy, would be in trouble. Because after all, if democracy means anything, it must mean that the structure of society is chosen. It's the product of collective self-determination, of collective choice, under constitutional constraint. An idea of democracy that it cannot be readily reconciled with this notion of the false consciousness of the agents who are actually thinking that they are creating through their struggles the content of the law. Now, there's an additional feature that increases our perplexity. And the additional feature is that the trouble is that there's not just one vocabulary of policy and principle, but there are a series of vocabularies. So take, for example, American legal doctrine now. I said that one of the characteristics of what I described as the third moment, the moment of darkening. Remember, the first moment is an institutional and ideological refoundation. There's a new settlement, like the social democratic settlement of the mid-20th century. And it gives the direction. Then there's a second period of normalization when the jurists work out in legal detail the legal implications of the settlement. And then comes a third moment of darkening when the settlement recedes into the past and ceases to speak to the fighting issues of today. And I described a series of characteristics of this third moment, which, broadly speaking, is our moment. That's the situation around us now. So one of the characteristics is the ironic and tactical attitude to this doctrinal practice. So it seems that the jurists don't fully believe in their own narrative of policy and principle. They half believe in it. So that's the spirit in which they write their law review articles, for example. They say, we know what we want, but when we come to write the article and to publish it, we have to do so in this official pietistic discourse. So it's like a Platonic lie. They lie, but they lie for what's supposed to be benevolent reasons. And so they clearly don't fully believe in their own narrative, and they have this manipulative or instrumental or tactical attitude to their own discourse. Another characteristic of the legal culture in this period of darkening is the central role of theory. So the settlement recedes into the background. So the proxy for the settlement is the real thing, it has blood, right? It's conflict, it's real history. Now it becomes a phantasm, a phantom from the past, and it needs a proxy. The proxy are these theories that the jurists come up with, these jurisprudential theories. So, and those are, of course, different in different countries and different nations, but they have the same character. So in the United States, in this historical period, first of normalization and then darkening, there have been three main families of theories. One has been theories of rights, liberal theories of rights, and then the discourse of policy and principle will be couched in the language of the theories of rights. The second will be law and economics theories, the normative use of right-wing economics or market fundamentalism, organized around ideas of allocational efficiency. And the third are legal process theories that say there are these agents in the legal system, the judge, the private order, the administrative agency, the legislature, and each of them has distinct roles and responsibilities and a method. So the problem is the plurality of these theories. So the claim that each of them makes is, my view of law is implicit in the legal material. Not completely implicit, but largely implicit. The narrative is not just a narrative that the jurist is supposed to invent out of nothing, just because he believes in it as an ideology. He has to say or to pretend that it's latent there in the legal material. But if he pretends that it's all there, his pretense becomes literally unbelievable, right? So he has to say, it's there in some inchoate, undeveloped form. I recognize it. It's all about allocational efficiency. It's all about liberal rights. It's all about the institutional proprieties of some legal process theory. And it's inchoate, it's not developed, but the lineaments, the prefigurement of the story is there. And my role as the jurist is now to complete the story, which they describe, man, as putting the best face on the law as part of their hermeneutic interpretive responsibility. So that's the intellectual construction. Now I ask you, is it plausible? Who can believe this? Because you're saying that the narrative of policy and principle is there, but there are all these radically different accounts of what it is. It's like you're saying, this object has a certain structure, and now come 5 different accounts of what the structure is. So the very plurality of the accounts fights against the idea that the story is already there. So the interpretive maneuver, the legal construction, has to involve the identification of the inchoate material and its completion. And then at the end, there's still the problem of the revisionary power, because you have to say that this narrative, once identified and completed in its best possible form, must still result in not accommodating all of the received legal understandings, but only some of them, so that you still are justified or required to exercise the power of revision, of rejection, which is the object of the third step of the argument. So there you have, and as I say, if you take seriously this idea that the doctrinal narrative is there and only needs to be completed, you still have the problem of what about democracy? The agents in democratic life, the political parties, the social classes, the races, the real communities of history, had different ideas about themselves. They didn't think of themselves this way. Were they the victims of false consciousness? Are they acting according to the instructions of some inaudible drummer who is telling them where to go, what to do? There's a hollowing out, a weakening of the ideal of democratic government under this notion. So I wanted you to be very clear about the implications of the 5-step argument and see how it renders this style of legal analysis in some fundamental way problematic. It highlights exactly what the points of tension are. Now, in the light of this restatement, would someone like to intervene? Is there something that you don't understand about this argument? Yes.
I was just wondering, you say that there is a settlement and then we forget about it, or it recedes in the past.
The which?
So the third moment.
The third moment, the moment of revision, yes. You leave that open because you say, we know what we need by way of power of revision for this style of legal analysis to operate as we expect it to operate, which is that there should be revisionary power, but it should be moderate. There shouldn't be too much of it. And then I said we have a series of candidates to give us that result. And none of them seem to be very good. So that led to what I call the solution of despair, which is to say, let's not pretend we have a good way of guaranteeing that we'll have this happy result. But if we practice in good faith the method of purposive interpretation of law described in the language of policy and principle, let's hope that that will be the outcome. That's the, I wouldn't say nihilistic, but skeptical solution to the problem at the third step of the argument. But what's the alternative to it?
Yeah, I mean, if we don't use these theories and focus on the actual struggle and history behind the law,
Yeah.
then this false separation between law and politics falls apart.
In the simple form, yes. So, of course, there would be an alternative that would avoid all of this, which is if our conception of legal reasoning were purposive, teleological, that is, we say the results in legal reasoning have to be shaped by the purposes we attribute to the law. If the attribution of purpose is not explicit, it must nevertheless be implicit. But we abandon the attempt to systematize and idealize. That is, the notion that there's this official vocabulary of policy and principle that has to be couched in some theory like law and economics or liberal theories of rights, and that has to evolve toward higher levels of coherence, of systematization. And in the United States, the legal theorists are always citing Lord Mansfield's phrase from the 18th century, the law works itself pure, meaning there's all this dross which is gradually winnowed out as there is a convergence to a higher level of rationality. And according to the terms of this skeptical response to the problem of revision at the third moment, we just hope that that's what will happen. That's what I meant by keeping our fingers crossed. But are we justified in having that hope? So, for example, Jeremy Bentham, some loose way related to the law and economics people, he had a coherent narrative, but his narrative resulted in a proposal to radically change the laws of England. So he couldn't serve as the basis for this principle based in policy-oriented solid legal reasoning, because the degree of revision that his method required was off the charts. And then you would say, well, that's not legal doctrine. Then he's like Kyrgyz. He's giving a constitution to the people. He's reforming the whole of society. And that's not what a jurist is supposed to be. So basically, at the end of the day, what this practice of legal analysis wants is for there to be a convergence between one, in an earlier class I called the prospective genealogy of law, the genesis of law out of conflict of real interests and conflict of visions or ideologies. That's the prospective genealogy. And the retrospective genealogy is the rational reconstruction of law in the language of principle and policy. And somehow, those two genealogies are expected to converge. But on what basis and with what consequence? That's the central problem highlighted in the five-step argument. And there would have to be, the solution would be to say, abandon the ideal of systematization, of idealization of law. Retain the purposive focus. Deflate your expectations about legal analysis. So it is purposive, it stays close to the ground, gripping the practical analogical reasoning, which is, after all, always the mainstay of the practical jurist. And by this deflated conception of its mission, it has real work to do. But that then leaves open the space to a higher mission. And the higher mission then is to inform the society in its attempt to understand its alternative futures. Now, what happens in the hegemonic jurisprudential theories is that they have only the idea of the lower mission, but the lower mission is inflated. So it occupies the whole space. So they say, we're not just doing analogical reasoning, we're not just implementing what the law says. We are in this exercise of improving it, of idealizing it. We're making it better as we apply it. And the greatest beneficiaries of our benevolent rationalizations are the weak or marginal groups most likely to have lost out in the politics and the conflicts from which the lawmaking came. That's their justification for their actions. And a radical Democrat might say, the people don't want to be the wards of the jurists. They don't want the jurists to be their tutors and to come onto the field of battle. And after the battle has ceased, to announce to them the hidden meaning of the laws. Yes.
So, picking up that last thread, I think the way so far, and correct me if I'm wrong, that I've understood sort of how you're approaching legal analysis is that it's not a terrain of struggle itself. And
it could be a terrain of struggle.
Like you have, just to tease that out a bit more, right?
Yeah.
Like you have people using law, jurists, in every, whether it's an associate somewhere or a judge in the Ninth Circuit or the Supreme Court
Yes.
or in an international organization, you have them wielding legal arguments in favor of alternative visions of the future, right? And
Yes.
and also in doing so, articulating different understandings or memories of the past. And so
Yes, although now just to correct, when the candidates for judicial office go to the U.S. Senate, for example, the senators grill them and ask them, when you're a judge, would you make your decisions according to what you think the law should be? Or would you say what the law is? And they all say, we're going to do what the law says, what the law commands. They claim that they'll do that.
It's true, but I'm curious. I guess the point of the intervention is to question the extent of, does interpreting legal analysis as a terrain of struggle, as a battlefield itself, shift our understanding of the five-step argument and the implications there too, right? Like the revisionary power, well, depending on the particular jurist exercising that revisionary power, may or may do, may lean on tradition and sort of.
So, but there's a rhetorical practice. In other words, this is not just like a philosophical dispute about two ideas of interpretation. So there's this question of whether the so-called progressive jurists should be favorable or not to the idea of indeterminacy, right? Which is, after all, what allows them more space to reinterpret the law. And here there is a stark contrast between the attitude that prevailed in the United States and the view that prevails in most countries in modern history. So in general, the left in law has been hostile to judicial discretion, right? And Bentham was hostile. Bentham was a radical reformer, and he said, the judges need to be bound hand and foot. And we should want them to stay as close to the ground of a literal interpretation as possible. It wouldn't be a stupid literalism. It has to be a literalism with some engagement with attribution of purpose. But it should be close to the ground. Because the judges are representatives of the elite, and we have every reason to be suspicious of them. In the United States, from the middle of the 20th century on, the legal radicals, the left in legal thought, became congenial to indeterminacy. And for example, they imported French literary theory. Suddenly Derrida appears as a figure in the hermeneutic disputes of American jurisprudence. Now, how is one to understand this? I think the simplest and most direct explanation is that it is an adaptation to their situation of political marginality. So the left in the United States, what I've heard always at the law school and in the faculties is the political dispute in the United States is a struggle between the center and the right. But at Harvard Law School or Yale Law School, the political struggle is a struggle between the center and the left. So the radicals feel that they have no national constituency. They don't represent any real force in society. So what are they implicitly believing? They're believing that we know that we're going to lose in politics because they always lose. But when the law comes into our hands, the legal experts, the law professors, the judges, it's wonderful because we can make it mean whatever we want to mean. No, of course I'm exaggerating, but this is a caricature of a true belief, which is the true belief is it doesn't matter who wins and loses in politics, because at the hermeneutic moment, the narrative of political victory and defeat can be reversed. Can it? I don't think so. So I think that when an attempt is made, so in the late 20th century, and we're going to come to an episode of this kind in a few minutes. In the late 20th century, the progressives took control of the commanding heights of the federal judiciary in the United States. And they did a series of things which were highly progressive and outside the mainstream of American political discourse. And then later on, as we know, the empire struck back. And the sequence of progressive judicial nominations was reversed, and the judiciary was put in its place. So that shows that at best this idea that indeterminacy can be used to change the options in politics represents a moment, a dialectical moment, which can be useful, but not a replacement for political victory. Yes?
I am detecting in your critique of classical social theory the idea of the
I haven't come to my critique of classical
Well,
socialism.
you mentioned
Oh, it's implicit in the five-step argument, I guess.
exactly
Yes.
that there is a suspicion that, like, you're suspicious of the idea that we're looking for hidden structures beneath things, beneath reality, or beneath the law. That there's kind of like
No, it's a particular set, well, so there's a particular set of illusions, right?
yeah.
So let's take Marxist theory. We're going to come to this later. So the classic criticism of Marxist social theory is that it overplays the role of functional determination, right? And so Darwinism is a functionalist theory. A functionalist theory is a theory that explains a phenomenon by its consequences.
Yeah.
Like adaptability to the environment is the consequence, which leads to greater survival of a certain population, and that becomes then the explanation. And that's thought to be the same thing in Marxism, that says a certain regime produces economic effects. And I think that this is in some respects a false criticism, because there clearly is a powerful element of functional explanation in history. typically, and this is a problem with Marxism, the same functional advantage can be achieved by alternative institutional arrangements. So, for example, the Chinese state can achieve a level of progress in the development of a knowledge economy comparable to the level achieved in the United States or in Germany. There isn't a one-to-one relation between institutions and functional advantages. So the functional story applies, but it's complicated. It's more complicated or varied than the Marxist narrative would allow. That doesn't seem to me to be the main problem in the Marxist narrative. The main problem is what I call the illusions of false necessity. That there's this closed set of regimes, that each of them is indivisible, and that there are these laws which have the consequence that history has a plot. That's the problem. So it's the combination of functionalism with what you could call the deep structure assumptions that's the problem. Now, this has significant implications for us in the following way. If I am to have any kind of programmatic discourse, a programmatic discourse about alternatives, I have to have a way of understanding structure and structural change. So I suggested that dilemma to you early about programmatic discourse. I propose something that's distant from what exists. You say that's very interesting, but it's utopian. I propose something close to what exists. You say that's feasible, but it's trivial. So everything that could be proposed in the current climate of opinion is likely to be dismissed as either utopian or trivial. That's the problem. Now, and you could say, well, that problem arises from a misunderstanding of the nature of a programmatic argument or transformation. Because it's not about blueprints, it's about successions, sequences of steps. It's not architecture, it's music. Huh? But now comes the other feature which dramatically accentuates or aggravates this problem. And the feature is the collapse in social theory and social science of any adequate way of understanding structure and how it changes. So Marxism in particular, and classic European social theory in general, had a way of explaining structure. But it was a deficient way because, for example, of these illusions of false necessity. The contemporary social sciences have disposed of the illusions of false necessity only by suppressing structural vision altogether. So for the most part, they are retrospective rationalizations of social life. So we don't have a way of understanding structural change. And because we don't have a way of understanding structural change, we fall back on this false, bastardized conception of political realism, which is that a proposal is realistic to the extent that it's close to what already exists. If it's far from what exists, it's not realistic. If it's close to what exists, it is realistic. Well, that, of course, is not an explanation of anything. That's just a declaration of intellectual bankruptcy, right? So that's the situation we're in. So that's the connection. So our lack of any adequate, usable, credible view of structure and structural change has a profound effect on all of our debates about alternatives, including the debates in legal theory.
But now there are kind of developments in social theory and sociological theory that are saying, or like rereading revisions of the canon, that are saying that, okay, perhaps we need to admit that Marx is a teleological Aristotelian functionalist thinker, but that his functionalism is not an explanation of this
I agree.
change.
So there are many attempts to create alternatives in social theory, alternative views of structure.
But I mean also like alternative views of functionalism. That to say that functionalism is not exactly an explanation of how social systems emerge. Functionalism is a necessary way of diagnosing a given.
Absolutely. So it's clearly true the different social regimes, institutional orders, prosper or fail because they provide or don't provide functional advantages, what works. And in history, the competition, the functionalist competition among regimes is not a theoretical competition against all possible alternatives. It's a competition with the real alternative, the rival, who's there as an armed state in front of you, right? So that's the real thing. And now we understand that there's the same functional advantage can be sustained by alternative institutional arrangements, which complicates the picture, to be sure. Nevertheless, going back to the debate about Marxism, what I would say is that most of the Marxist revisionism, the attempts to escape the consequences of these delusions of false necessity, has had the character of dilutions. So what I mean by that is cultural Marxism, political Marxism, emphasizing the relative autonomy of culture and of politics from the so-called base, the superstructure relative autonomous from the base. Most of the revisionism has had that character. In other words, rather than radicalizing the central insight into the made-up nature of social life and its reinvention, it's been a kind of weakening, that's why I'm calling it a dilution, of the heroic premises of the orthodox view. And so it's not successful in that respect. And it results in what I think is a pervasive confusion in the discourse of the left, which is having ceased to believe in the heroic assumptions of the theory, it continues to use the vocabulary. So all these concepts, like the concept of capitalism, which is a very contested, unclear concept, have a clear meaning in the context of the orthodox theory, but they don't have a clear meaning when they're taken out of that context. So, and so this results in pervasive disorientation, which is then an element confounding our attempts to have programmatic debates. Now, I think that one of the attributes of a credible view of structure is that it represents the structures at the level of significant detail. So it can't be just like the market economy, you know? Or sometimes Marx emphasized that labor could be bought and sold. There have to be a whole set of detailed things which define a particular structure, ideological and institutional. And where are these details? They're not in economic ideologies, they're in the law. That seems to me to be the paramount comparative intellectual advantage of legal thought in engaging the idea of structure. This advantage is then surrendered, it's forfeited when the jurists go into this idealizing and systematizing discourse of the rational reconstruction of law. So I think it's just a huge disappointment. We've gone through all of this. We need legal thought as part of the solution, practically and intellectually, but it's now engaged in the silly principiology instead of doing what we need. That's the kind of argument that I'm making. You have a comment about that argument, or?
I do have a comment about that argument. I'm wondering whether this is only just simply about Marxism or social theory in general, too. Because I'm thinking of other examples of sociological thinking that are not Marxist and yet have functionalist assumptions. Are they also subject to the same critique? So, for example, someone like Durkheim, for instance, when he's talking about animal theory.
Yes, yes.
Which I still think is a very powerful explanation of modern society. Is that still vulnerable to that same suspicion?
It's powerful about something else, right? It's powerful about the nature of social cohesion, where it comes from, how one is to understand it.
Yeah, it is based on a functionalist reasoning in a way. That
Among
there is
other
a-
things, yes.
That there is a purpose to social society. That there's a purpose which is cohesion. And I'm wondering whether your critique is applying wholesale to classical social theory at large, which includes certain ideas about
Like Durkheim.
like Durkheim, which is embedded in teleological thinking in the end, or is it just simply about Marxism?
Well, so we have to have a discussion of social theory, right? So I think in Marxism, the focus is on the problem of subjugation and power and its relation to these functional advantages. In Durkheim, as you say, the focus is on solidarity and the idea that this? Oh, my watch is on the floor. Okay. We could get rid of time that way, right? So the focus is on the way in which solidarity can be generated out of differentiation. Durkheim never had an adequate solution to this problem, because I think the solution that he proposes in the book on the division of labor, for example, is that there's an ideal, a conception, autonomy which is shared in the society, and so are really not convincing. That is, if cohesion is something structural, it has to have a structural basis, and it can't be based just in an idea. Now, I think there's a third problem in classical social theory, which appears only at the limits, which was never formulated clearly as a problem of social theory, except indirectly by people like Weber and Freud, under the categories of cathexis, decathexis, rationalization, disenchantment. It's the problem that we call the problem of warmth. Warmth. So in the traditional societies, in the pre-modern societies, there was always a combination in the same relations of exchange, power, and affect. So, and it's like slavery. The ideology of slavery is we're one big happy family. So the characteristic social relation is the sentimentalization of unequal exchange. It combines these three elements, right? And then when the three elements are separated, power for politics, exchange in the market, affect in the family, then society, as it becomes freer through this disengagement, also becomes colder. And this is also a problem, a central problem. How can we become freer, both free and warm, rather than free and cold, according to the fate which Max Weber and others says awaits us, inevitably. There are all these problems, but there's one respect in which these problems are not alien to our discussion, which is that all of them must have structural expressions. It can't just be an idea or a cultural phenomenon. So, for example, what I think about this third problem, this problem of warmth, is directly related to part of our discussion here. I think that in these contemporary societies, the source of warmth can no longer be the family. It's not some emanation of family affect, which is what the social theorists like Tönnies believe. The source of warmth has to be innovation. The imagination is the source of warmth. And it's this ability perpetually to create the new and to jumble up the cards, right? To engage. That's the source of warmth.
You don't think that nationalism plays a role in creating war?
Absolutely it does, but it's in a very restrictive form, right? Nationalism is clearly a source of warmth, and especially when it results in war, which is a super source of warmth, though a warmth that we have many reasons to resist. So then we might think the economic and political institutions should have among their central attributes that they are instruments for the perpetual creation of the new. An experimentalist market economy is always changing its own institutional framework. A high-energy democracy is loosening the dependence of change on crisis. And that's where I want warmth to come from. But that determines on institutional detail. So how in detail are we to organize an economy that makes this radicalization of innovation possible? And how are we to organize a political life that allows us to change without having war or economic collapse as the enabling circumstance of change? That's where I want warmth to come from. So all these classic problems of social theory, the ones that are discussed in the canon, like the problem of solidarity and cohesion, and the ones that aren't discussed, like the problem of warmth, in the end turn on structural changes. And that's why this issue of the fatal character of structure becomes so important. And that's what I hope we'll come to in the next class. Now, there's one other point related to the five-step argument that I wanted to bring up in this class before we end. And it's this ambiguity of rational purposive, policy-oriented, and principle-based legal reasoning. It's ambiguity with respect to transformation, because I've taken the position that on the whole it is conservative, it's anti-transformational. But that's not completely true. And I want to show you how there's a twist to this in the evolution of this legal culture. I'm going to give you an American example. So this view of law is very ambitious, right? It's idealizing. And it allows you to attribute to law not just specific purposes, but very general purposive projects, like, for example, an anti-subjugation idea. So there's this rationalization of law. It's a body of principles. The principles are generalized upward, and they can be very ambitious, like the idea of anti-subjugation. And this exercise in the United States in the closing decades of the 20th century led to the formulation of a revolutionary procedural device, which is called in the American vocabulary the structural injunctions or complex enforcement. So what began to happen is this: the judges attributed to the law these very high ideals, the progressive judges, the left liberals, who were appointed to judicial office in the United States in the closing decades of the 20th century, before the conservative reaction set in. So they attributed these high ideals, and they said, if we impute to the law an anti-subjugation ideal, there are certain practices or particular organizations that are in clear defiance of this ideal that we're imputing to the law. Especially, for example, mental hospitals, prisons, school systems, a bunch of institutions that are either relatively marginal to society or at least occupied mainly by marginal people like children. And they said, the practice in these places is in defiance of our ambitious, idealizing, rationalizing interpretation of law in the vocabulary of policy and principle. Therefore, we must go into them and change them. So they began to develop an entirely different procedural device, which, first of all, the agents were no longer individuals or representatives of particular economic interests. The agents were whole categories of people, of races, of classes. The evil that was supposed to be redressed was not just a violation of someone's right. The evil was this contradiction between practice in a particular social organization and the ideal imputed to the law. And the remedy was not just to reaffirm the correct allocation of right. The remedy was to invade part of the causal background of social life and reshape it. So the judges would go into a prison system or a school system, and they'd say, this is no good. We'll delegate its fixing to an independent expert of our confidence, a special master, as it was sometimes called. And this expert will then reorganize it and remove the evil, and then return it fixed. So this is, everything was different from traditional procedure. The agents were collective rather than individual. The evil was structural, and the remedy was also structural. But it was structural, but it was also local or episodic. Now, in the three-branch state of the executive, the legislature, and the judiciary, which power is suitable to an intervention in social life that is structural, to restructure, but episodic or limited, not general? So the administrative agencies are not supposed to restructure anything. The Congress is supposed to act under general rules, not to have localized interventions. The president, much less even. So there was no agent who was appropriate to this task of undertaking a form of intervention that was structural but localized. So then what happened? The judges did it. And why did the judges do it? Because they wanted to. So the real situation, there's no agent adequate in the existing institutional system to do this work. And there were two opposing principles. So one principle was, if the law gives you a substantive mandate for transformation, implement the mandate, regardless of whether there is an appropriate institutional agent. The second principle was, if the law gives you a substantive mandate, implement it only to the extent that there is an appropriate agent. So what did the judges do? They simply arbitrarily split the difference between these two principles. They were willing to implement the mandate to some extent, but not fully. So, for example, they chose relatively peripheral institutions. Why didn't they go and restructure the banks, for example, instead of restructuring prisons? Because no one would allow them to get away with that, obviously. So they couldn't do that. And everything in social life is connected to everything else causally. So when they invaded the structural background, why did they stop where they did? Why didn't they just continue? After all, the injustice in a prison or an insane asylum is connected to lots of other things in social life. Why stop there? Why not continue going on? So they just stopped where they had to stop. They stopped until they ran out of power, is the real answer to the question. So the procedural framework, so that the law could be hyper-rationalized in this idealizing form, the procedural framework was derationalized. That's the arbitrary splitting of the difference between these two principles in this way. And that shows this ambivalence that even as rational reconstruction in the language of impersonal policy and principle inhibits clear-sighted structural engagement with society, it sets the stage for these episodic interventions. And this is just to do justice to it and to show you its ambiguities in relation to transformation. Now, what do you think of this story? It's an interesting story because you know, the central ambiguity of this, going back to the first class, where I gave that account of the difference between 20th century and 19th century legal thought. Remember, one of the columns there was the central division, the mission on the self-understanding of 19th century legal science was secure these rights, the system of private rights, and the background was a system of public rights, defining individual and collective self-determination. Secure those rights and you will be free. Then comes 20th century thought, and it reorganizes the law as a dialectic between the rights of self-determination, individual or collective, and the conditions for their practical exercise. So as I said, like in labor law, say, there's contract law in the employment relation, but there's radically unequal bargaining power. So by unionizing the workers, by collective bargaining, we will reestablish the reality of contract under the very unequal conditions of the bargaining relationship. And it did that, all of law was reorganized on that basis. So I gave you an example of the relation between two disciplines, labor law and contract law, but the same thing was within contract law, for example, in the interaction between the rules of contract formation and the rules about unconscionability, and with respect to all of public law in relation to private law, because all of public law was designed to secure the conditions for the practical exercise of autonomy in private law. Now, as soon as you realize that the exercise of self-determination of autonomy is not automatic, but depends on practical conditions, the normal thing would be to say, there's not one way of defining what those practical conditions are. You can define them in different ways. And so naturally, the plurality of views about how to secure the conditions for the exercise of rights would lead you into the discussion of institutional alternatives, because the different ways of determining the practical conditions are previews, prefigure institutional alternatives. But it stopped there. It didn't go on to that next step. But then we come to the complex enforcement, the structural injunctions, the story that I just told, and you see it didn't stop completely. So under a different set of political arrangements, you say, this state has no power that is suited, designed, and financed to do this work of reconstruction that is structural but episodic, localized. So let's create another power in the state that is explicitly designed to do that. It will be elected directly by the people, or it will be co-elected by the political branches, and it will be financed and equipped to do this work. And that would be the normal way in which things operate in the world. You say, there's a mission, a transformative mission. There's never an agent for the transformative mission. The world is organized to reproduce itself, not to change itself. So if there's a project of transformation, almost by definition, the agent for it doesn't exist. So then you seize on one of the agents. In this case, in the United States, it was the judges. Could have been anyone in a different country. Could have been the administrative agencies. It could have been the legislature. And they'll do it incongruously until you form the agent. Now, you were going to say something.
Yeah, I'm mostly because I think what this boils down to is a constitutional question, and constitutional both in sort of the constituent elements of the socioeconomic, political order, but also constitutional within the like founding charter, body of law, foundational law.
But I suppose an orthodox constitutional lawyer would say all of this was unconstitutional.
Well,
I mean, that would be the conservative view.
So this is, I think, that's exactly where I was going, which is when you have a foundational law that actually inhibits the extent to which you can have a substantive mandate for transformation, right? Like, we have a set of political institutions as developed in the Constitution that facilitates slow, incremental progress or total gridlock, right? It's not.
It's especially designed to facilitate gridlock.
Right, but and so, I guess, like, especially in a social, political, legal environment that glorifies the founding document, and I think you run into tension because you want fixity to preserve or protect particular rights to those can never be violated. And if you lean on this like contemporaneous consent slash, the alternative, which is like a living, breathing constitution that we can play with, there's a lot of movement in the joints, and we abandon fixity entirely, then we open up the space for oppression of those rights.
That's
right?
the liberal view. That's not my view. That's the liberal view.
Well, I think you do by virtue of, right? Like you no longer have this fixed.
Yeah, so the liberal view, so the classic liberal view, the orthodox liberal view is in order to have these rights, you have to take something, the arrangements that define the rights, out of the agenda of short-term politics, right, and entrench them in the Constitution. And then you have to surround the Constitution with an aura of sanctity so that the idea of changing it itself is blasphemy, except in extreme situations, right? But what I would say, of course, is that that's all an illusion, that we can't tie our hands to the mast in that way, that there's nothing outside the storm of history, and that if we, that it's, so what essentially is this idea of fundamental rights, right? So it has a formal aspect, which is this notion of creating supermajorities, entrenching, making it hard to change, taking it out of the agenda of short-term politics. And it has a purpose. And what's the purpose? The purpose is to say, we'll give the individual a haven so that he can flourish and act in the midst of a storm around him. So I say to my child, you have an unconditional place in the world now go out and raise a storm in the world. So the haven is the reverse side of the storm. That's now, so liberal social democracy has this discourse about the haven, but it has no discourse about the storm. The storm doesn't happen automatically. The storm of innovation, of conflict, of what I was calling the perpetual creation of the new, has to be arranged. That's the right way to think about rights. The liberal thinks of it only as this protection against the storm.
But there's substantial risk there, though, right?
Of course.
Like we can't predetermine the outcome.
Of course there's risk.
And whether a new haven even emerges after
Yeah.
the storm. And
Of course.
I think it's tough to say, well, your risks or your rights are on the line. And I think, is there a way to reconcile those competing stories of what that sort of founding document does? Can we preserve some notion of fixity, some notion of inviolable rights with this idea of expansive, transformative reconstruction or reimagination of institutions? I think that should be
But doesn't it ultimately depend on an idea rather than a practical relation? That is, the individual has to be safeguarded against private and public oppression.
Yes.
And empowered. You know? But the practical forms of safeguarding and empowerment will change with historical circumstance. It's no good saying there's some sacrosanct formula which, invented in the 18th century, for the sake of security, we have to keep.
Experience teaches us to be
Yes,
skeptical of
I know. Well, yes and no. I mean, but then we come back to the debate about the liberal idea of neutrality, right? So the liberal says there's a framework which is neutral among visions of the good. I say the liberal pretense of the neutral framework is always adduced in favor of its opposite. So we claim something to be neutral in order to entrench it against challenge and change. And so this is a false idea. No institutional system is new. We would like it to be, so that tomorrow we don't have Mussolini or we don't have some other thing, but we can't. That's not the nature of historical experience. Alfred North Whitehead taught us the business of the future is to be dangerous. And we're not going to find this perpetual motion machine that will secure us against these dangers.
It is a risk-loving approach.
A risk-loving approach. Let's say it's an embrace of the reality of historical experience. Okay, we've exhausted our time, and I am expecting to see your provisional projects. And next week, I still want you to have in mind the essay on the universal history of legal thought, because next week, the central topic will be structure and how we should think about it and its relation to these debates about legal theory. And I expect to see all of you soon to discuss your projects. Are you at the law school or somewhere else?
I am a fellow at IGLP with David Kennedy.
Oh,
I'm a postdoc.
but you are a lawyer?
No, I'm actually trained as a sociologist, but I do sociology of law now.
I see.
Yeah,
Okay.
that's why my questions are coming from that direction. Yeah.
Because usually the law school has been resistant to having non-lawyers. So
Yeah.
the visiting researchers, for example, all have to be lawyers.
I think think that David Kennedy makes exceptions.
Yes, of course.
Because of the kind of work that we do.
Of course.
Perhaps I could come, like, could I visit you
Absolutely.
during office hours to...
No, I don't really have office hours. I just see people after these classes.
Oh, okay.
All of them. So Monday, Tuesday, and Wednesday I teach until 3,
Yeah,
and I'm in my office after 3,
yeah,
and Thursdays until 3:30.
perfect. So I will...
Just show up. You don't
Yes.
have to make an appointment.
Perfect, all right.
Good.
Thank you.
All right. Tudo bem?
Tudo ótimo, professor. Sobre o que? Se o senhor for passar...
Está muito doente. Então eu combinei com o Guto
Tá,
que eu vou lhe dar um cheque
tá,
para você entregar a ele.
tá bom,
Tá bem?
tá ótimo.
Quando jantarmos, eu lhe dou o cheque.
Tá bom, combinado. Combinado. E
Ele vai fazer um Pixie lá no Brasil, uma série de Pixie para ela,
tá.
e você dá a ele o meu cheque.
E ela tá bem assistida na Bahia? O senhor tem família aqui?
Eu não sei, ela tem um câncer muito grave, né? E eu acho que novamente é o problema de cultura, né? Da cultura brasileira. Então ela teve uma tosse persistente. Tinha tido Covid. Então atribuíram a tosse à Covid.
Então, Covid tardia. Não fizeram exames.
E a minha pressuposição é assim, há um sintoma persistente e há 5 explicações possíveis, sempre é necessário pressupor a explicação pior. Mas eles não pensam assim. Quer dizer, o problema metodológico que levou a esse desastre.
Sim. Inclusive, hoje o senhor fez uma crítica contundente ao pensamento de Luhmann, que é um funcionalista.
Ao quê?
Ao pensamento de Luhmann,
Sim, sim.
funcionalista.
Sim, que é muito nessa linha de functional differentiation, Durkheimiana e tudo. Hi.
Hi, so I was wondering, I was reading Duncan Kennedy's article about political economy of contemporary legality, and he's talking about how the legal elites are usurping more and more power and then are faced with the legitimacy crisis. So when you...
I don't know this particular article.
Well,
never
I
read it.
think it's also connected to the hermeneutic of suspicion and all that.
Uh-huh.
So I was thinking when you say that the legal analysis should be deflated and more analogical and less system, like no system.
It is in the exercise of its narrower mission,
Yeah.
in part
Yes.
to create space for the bigger mission. So it's not that the legal thought should be deflated overall. I think the opposite, that it should assist society in its transformation. But for that to happen, because the paradox of this stuff here, this principiology, is that it's very high-flown, but it's a high-flown thing about something that is itself little, right? There's judges and lawyers, attorneys deciding cases, representing private interests. So it has a high-flown version, a high-flown interpretation of a little thing. I want there to be a deflated interpretation of the little thing, so there can be space for the really high-flown thing, which is the other thing.
But would this mean that the judges would need to, or the elites would need to renounce on their power that they now have
No,
to solve
no,
social questions?
There's no reason why we in Brazil, for example, should be treating this Dworkinian or Alexi-style legal analysis as if it were the wave of the future. This is a superstition that we import from Europe and from the United States, which is inappropriate to a society that wants to experiment with its future.
Maybe it could be the opposite. These legal elites should be more ambitious to start to think about bigger things. But we have some advantages in the lower vocation, for example, methodology, definition, tradition.
Yeah.
Start the new without an objective methodology and traditions, much more difficult.
Because, you know, the hermeneutic posture, the posture of the legal theorist imagines himself as a kind of super judge, whispering into the ears of the judge, So Dworkin's book is called, Taking Right Seriously, Hercules and so forth. It's always these images, the supreme power is the judge. And if you go to the faculty lunchroom at Harvard Law School, what they're all talking about day and night is the Supreme Court and the judges. I always tell them, if you think it's so wonderful to be a judge, why don't you become a judge? And why is someone going to have an activity which is not what he himself regards as the highest activity? That doesn't make any sense to me. But their imaginative focus is on adjudication and disputes about that and so forth.
So you're not saying that judges should be deciding less things or few.
No, I'm not saying that
But the
at all.
problem is the
I'm not saying
judicialization
that.
of politics.
I'm saying that this activity in which adjudication and the professional representation of interest is confused with the development of a system of policies and principles is a profound error. The less significant error is it's a mystification of law, and it results, and it has a series of evils like usurpation of power by the legal notables, but that's not the main evil. The main evil is that the space, the social and imaginative space for the higher discourse is taken away. So instead of discussing the detailed reorganization of the structure of society, we're discussing this other thing, like how the case is to be decided in the court and so on.
But it is true that if you propose a transformation of society, then this case will end up at the Supreme Court eventually.
It will lead to other cases, that's right.
So
That every political transformation will generate trouble for the lesser, work for the lesser vocation. Although I think that one of the motivations of this approach to law is, frankly, the desire of the jurists to do important work in their historical moment. What about us? So we don't want to just be slavish appliers of the law. We want to, as we do that, we want to be able to see ourselves as implementing a higher mission. That's clearly one of the most significant motives behind this desire for idealization.
So they would need to replace the prestige they get from this idealization
With a higher prestige.
with the
Yeah.
visionary politician style.
Yeah, it's a tough call, right? Because they want to be priests.
Yeah.
I want them to be prophets. And there's a huge gap between being a priest and being a prophet.
Much more ambitious. That's great.
Okay. And I was just wanted to ask you, is there any accessible reading of Whitehead and how it influences your thinking of? Do you think there is no essence, there is just change, or?
No, so I think Whitehead, one of Whitehead's most attractive books, his metaphysical works are very difficult and obscure. I think a book he has called Adventures in Ideas, because it's applied to episodes in intellectual history, is very good. I would recommend that. But I'm not, in general, an advocate of Whitehead's philosophy, because I think a clearer, first of all, a more attractive philosopher, a more beautiful writer is Bergson, Henri Bergson. Wonderful writer. Bergson, Henri Bergson. So wonderful. But this whole line of philosophy of Bergson and Whitehead, there's something I like about it and something I don't like about it. What I like about it is its insistence on the reality of time. History is open, time is a central part of experience. What I don't like about it is their view that there's a protagonist, which the hero of the story, which in Bergson is Elan Vital. It's like a Bildungsroman in which the hero emerges as the Geist that presides over the thing. And so they have this narrative that you haven't seen anything yet, right? I like that part. The roots of a human being lie in the future, not in the past. And God is the ultimate form of the universe. It's something in the future rather than something in the past. But that then is associated with this idea that there's a narrative, a script, it's already been written. And it has a hero, a protagonist, who is the central figure that emerges out of it. I don't like that part.
But just one last thing to get to the previous point. So, for example, you only want to focus on the higher mission of legal thought, but the fact that we are now...
No, I don't want to only focus on that, because I think the lesser mission is extremely interesting. So, for example, just take a typical example. This rationalizing idea of legal thought radically suppresses two things, two other forms of thought, aside from purposive and analogical reasoning. At the lower level, equity, at the micro level. What is equity? Equity is when the judge perceives an opportunity to depart from the law, from the formal result, without threatening the structure. And at the top of the system, judicial statecraft. So, for example, if in one of these contemporary democracies, the political branches are tied in some way, they're at an impasse, and there's a national problem which they have not solved or unable to solve, the judges can cut the Gordian knot through an act of judicial statecraft. And the act of judicial statecraft is, among other things, an appeal to the future, to the society. So in itself, they don't have the power to determine the solution. But by cutting the Gordian knot, they can appeal to society, to their allies outside, to come to their assistance. So I think that's a much richer version of this narrower professional vocation, in which there's this purposive understanding of law, which realistically takes into account the contradictory views in each legal discipline. There's a central idea, there's a penumbra of exceptions, and then it's bounded on the lower level by equity and on the higher level by statecraft. I think that leads to a richer view of this professional practice than this stuff, because this stuff reeks of the academy. It's sort of bookish. It's like a view of law by someone who doesn't do law. That's one of its paradoxical things.
Okay.
Because I don't think that a working judge would spontaneously come to ideas like the idea of Alexei or of Dworkin. I think those are ideas of someone who's never been a judge and who doesn't deal with the reality of cases and people and so forth. So it's against reality and also against the interests of the ascent of the spirit. So I'm against it on every count.
Okay, thank you.
Thank you.
Professor, acho que ele quer falar com o senhor. Vou esperar aqui fora.
Tá bem.
Eu te acompanho até a sua sala lá.
There.
Tá bom?
You want to speak with me?
Yeah.
Okay.
É fato. Mas, professor, o senhor tem quem esteja acompanhando ela lá, na Bahia? O senhor...
Eu tenho uma filha adotiva,
Tá.
que tem 18 anos, está dormindo com ela quando pode.
Mas em que
E
hospital?
tem a minha